morning, everyone. Thank you for joining us for our first business resource webinar on COVID-19. I'm Kim Casco, President and CEO of the Iowa City Area Business Partnership. It is our mission at the Business Partnership to serve our local business community, and that is more important than ever right now. The purpose of these webinars is to give you the information you need to figure the next steps for your business as you navigate this incredibly challenging time. Today's session will focus on the Family First Coronavirus Response Act and Iowa unemployment. A few logistical things before we start. Everyone except for myself and our presenter has been muted. Our presenter has a lot to cover today, but we'll try and leave some time at the end to answer questions. As you have questions, please post them to the Q&A section. The session is being recorded, and we will post the recording afterwards. And lastly, this is our first webinar, so we might be working out some kinks here. There's also a high volume of traffic on these webinars that may cause some sound interruptions and issues. And so let's just hope for the best here. I'd now like to introduce our presenter, Brenda LaMarche. Brenda is a small business owner herself and the founder and president of BRL HR Consulting. Her company provides human resources and payroll services to small businesses nationwide. Brenda has worked as a human resources generalist across companies of all types and sizes since graduating with a degree in human resources and industrial relations from the University of Iowa. She is a committed volunteer with Rotary and a member of the Society for Human Resource Management, the Cedar Rapids Metro Economic Alliance, and the Iowa City Area Business Partnership, where she is on our board. Besides helping her clients with everything HR, she does presentations around the community. Thank you, Brenda, for joining us today. I'm now going to turn things over to you.
Good morning, Kim. Thank you very much for being willing to host this particular webinar. I think this is just a really important topic for a lot of people right now. It's on the front of mind for more people than I would like to admit. If there's any questions or concerns, like Kim has mentioned, please go ahead and use it through the Q&A session on the screen. I'll try and get through all of the information as soon as possible. Today, we're going to talk about the Family First Coronavirus Response Act and the Iowa unemployment and what's changed to try to assist and aid both workers as well as employers. The agenda today, whoops, sorry, I apologize. The screens are moving really slowly today. The agenda is the FFCRA, which is the Family First Coronavirus Recovery Act. The second thing will be Iowa unemployment, a to-do list, and then try and get through all of your questions as much as possible as we go through this particular webinar. The COVID-19 coronavirus is also known as COVID-19. This is actually specifically a respiratory illness that spreads through the community through others that have actually contracted the virus by coughing, sneezing, runny noses, etc. And it can also be spread when people are touching surfaces that people have sneezed on and then touch their faces. The most at-risk population is known to be those that are over age 60, as well as those that have underlying health conditions, especially things like diabetes, heart disease, as well as other types of respiratory types of illnesses. The U.S. Congress has actually enacted the Family First Coronavirus Response Act. They've done this in an effort to try and alleviate and help employees when it comes to this situation where businesses are shutting down and the states are actually having businesses shut down specifically. The law was actually signed into effect March 18th of 2020, and it becomes effective April 2nd of 2020. This particular law is very unique in that it was put together very quickly. Some of the verbiage within the law can be interpreted in a lot of different ways, but ultimately what it boils down to is that the President requires employers with fewer than 500 employees to be paying emergency family and medical leave, as well as emergency sick leave to employees during this time frame. And let's go ahead and talk about what that's going to be. And another important point to note is that this law actually is set to expire December 31st of 2020. First, the emergency sick leave law. This one is relating to paid sick leave for employees when it comes to having to be off work due to federal quarantine or state or local quarantine or isolation order related to COVID, or it's related to if an employee has become ill with COVID-19 specifically, or is experiencing COVID-19 types of symptoms. In those three examples, employers are required to pay employees up to 2 weeks, up to a total of 80 hours to be paid, and then prorated for part-timers for emergency sick leave. The rate of pay is going to depend on the reasons. So the first three reasons that I gave, basically those that have become ill or mandated to quarantine because of the illness, are eligible to receive up to 80 hours of paid time, 2 weeks, at 100% of their regular pay. This is capped at $500 a day. Then, if the other three reasons, if an employee has to be off work because they're caring for an individual subject to an order like, for example, a spouse becomes ill with coronavirus, then they need to care for that spouse. Or if they're caring for a child because school is closed because of COVID-19, or they are experiencing any other substantial similar conditions related to a health condition that the Secretary of State or Treasury is requiring isolation again because of the family member, then they get paid 2/3 of their regular rate when the employee can't work because they're caring for somebody else, and that is limited at $200 per day. Please be aware that the reasons the pay is different is because it depends on whether or not it's affecting the employee directly or if it's a family member. Employers cannot require employees to find their own replacements if the employee has to be out ill or needs to be out on emergency sick leave for any of the 6 reasons we just talked about. This emergency sick leave, please be aware, is paid in addition to any company policies that you have in place as of April 2nd of 2020. Part-time proration for average is based on average hours worked during the prior 6 months of employment or the equivalent. Or the other equivalent that I've been reading through several different posts also includes for new hires expected hours that would be worked during a 2-week period. This particular law applies to all employees regardless of length of employment. The Emergency Family and Medical Leave Law is relating to employees that have been employed for 30 or more days. Employers with fewer than 500 employees are required to pay up to 10 weeks of paid leave if that employee needs to be on a bona fide leave to care for a child when school or daycare is closed due to COVID-19. This is the only reason for emergency family medical leave for employers under 50. Employers over 50, please be aware you may need to coordinate with family medical leave if they're having to take care of a child because maybe the caretaker for that child is ill. But this is specifically, I'm not covering all of the ins and outs of the Federal Family Medical Leave Law. I'm only covering the Emergency Family Medical Leave Act that's part of the FFCRA effective April 2nd. The first 10 days for employers over 50 employees is required to be paid, I'm sorry, the first 10 days can be unpaid, if an employee is out due to having to care for their children. Please note, however, the emergency sick leave law overrides the first 10 days for employers of all sizes and fewer than 500 employees, and that means that the first 10 days is still paid. So you're still paying 12 weeks of time off if that employee is off to care for their children. This is capped at $200 per day and is paid at 2/3 the regular rate of pay. Please keep in mind that if you're calculating out the 2/3 the regular rate of pay, you still cannot take that employee below minimum wage. So it'll either be 2/3 the regular rate of pay or minimum wage, whichever is less. I'm sorry, whichever is more. I can't even do my own words today. So job protection is required under the Emergency Family Medical Leave Law that states that an employee must be reinstated to the equivalent or same position upon returning to work, the same as the federal family medical leave. The employees can elect to substitute accrued paid time off during any periods of unpaid time, but an employer cannot require an employee to do so. Please be aware that both for the emergency family medical leave as well as the emergency sick leave, there are tax credits available to employers that are required to pay this leave, that are required to provide leave, and that do not do so voluntarily. Those federal tax credits are actually a dollar for dollar type of tax credit that you would actually claim on your tax returns and on the 941s each quarter. The qualifying wages that you can potentially claim through the IRS for those dollar for dollar tax credit would include wages paid to employees who take a leave for qualifying reasons, which are not voluntary leaves. So we've had several situations come up where employees are choosing to self-isolate in businesses that are considered actually essential, such as daycares, grocery stores, hospitals, etc., that are refusing to work. In those particular cases, that is a voluntary time off that can be unpaid, and an employer is not required to pay during a voluntary isolation. So qualifying wages would include wages that are required to be paid for the FFCRA. It is also not to exceed the individual per diem and aggregate payment caps that are required. And the tax credits can also include the health insurance costs during a qualifying leave. So if you continue to pay your health insurance premiums for your employees, it'll be important to know that you can also add in and include the health insurance costs on that dollar for dollar reimbursement on your 941 returns each quarter. Please be advised that employers are going to be required to include the amounts of any of these credits that you receive through your 940 returns in your gross income to prevent a doubling of benefits. So you cannot take the credit and also claim it off of as an expense under your income. So you cannot, no double dipping allowed, even though we like double dip ice cream cones. The 30-day non-enforcement period for good faith compliance efforts is actually protecting employers just so that you can try and comply with these in good faith, and will prevent you from civil litigations in that first 30-day period to comply with this new law. There will be a notice that has not been made available yet from the Department of Labor as of 6 a.m. this morning that you are going to be required to be posting to your employees for the notification of the FFCRA requirements. This will need to be posted where you post your mandatory posters, you know, your all-in-one labor posters that you post next to your time clocks or wherever it is in your employee break rooms, but it must be in a visible location that employees would have ready access to. If you have remote workers, the recommendation is to make certain that you're putting those remote workers and emailing this notice directly to them to ensure that that information can then be provided to all of your employees, both working and remotely. I do need to go back and make one quick correction. There's a typographical error in the in my presentation. The cap for the employee sick leave for an employee that is actually ill is $511 per day, not $500. I do apologize for that typographical error. Secondly, I do want to respond at least a little bit to some of the questions that are out here about FFCRA. I stated that over 50 employees for emergency family medical leave does not apply. It does apply because of the sick leave side of things. And the sick leave side applies to all employers. So you, even as a small employer, you have to pay that first 2 weeks of under emergency sick leave if they have to care for their child, care for another person, or they're out ill because of themselves being ill. So the reason why I had mentioned the 50 employees mark was because that's what the law, the verbiage in the law itself says. but employers are still going to have to follow the compliance of paying that first 2 weeks in addition to potentially up to 10 more weeks under the emergency family medical leave. Thank you for asking those questions. They're very good questions. And thank you for the person that caught my typo. What I'm going to do now is I'm going to go ahead and move into the Iowa Workforce Development section for unemployment claims. So at present, one of the things that I'm seeing is a large volume of small businesses that are either shutting down or laying off large portions of their employees because revenues are obviously dropping for many, many businesses. And, you know, you have many people struggle with, you know, no revenue coming in, I can't pay people. So who can file for unemployment in the state of Iowa? According to the Iowa Workforce Development, you can file for unemployment in the state of Iowa if you cannot work because you are caring for a family member, loss of child care or school closures due to the COVID-19, the employer has shut down, or there is a need for an employee to self-quarantine. Employee contracts, if the employee contracts COVID-19 and is also unable to work, and business owners may claim unemployment due to the COVID-19 shutdown. Many people have been asking me the question about whether or not business owners can file, and the Iowa Workforce Development is going to be taking each one of those requested claims and reviewing them individually based on those business owners that do file, but they are going to be opening that up to allow business owners to file potentially and receive unemployment benefits during business shutdowns, especially when it's been mandated by the state to shut down their particular business. The company should be reviewing and looking at their PTO policies and comparing how their PTO policies interact with the FFCRA and Iowa unemployment. When talking with Iowa Workforce Development and several different attorneys, the recommendation is that prior to laying off employees, companies should be paying out and exhausting any available company paid time off. Iowa Workforce Development is specifically asking each person that files for unemployment whether or not the company has actually paid available time off to them. Once the employee has exhausted any available paid time off, then it would go into the FFCRA. Once the employee has exhausted any mandated FFCRA, then the employee would be eligible to file for unemployment. To be eligible for unemployment, however, and to receive unemployment benefits, the state has still maintained that an employee must still have a certain amount of wages covered by unemployment in the last 15 to 18 months prior to filing their claim. So basically, as long as an employer has claimed an employee on their unemployment tax returns, they would still potentially be eligible for some benefit, and they do actually review whether or not that employee has shown income reported on an employer's unemployment tax returns. Please be advised, I've been getting a lot of employers calling me and asking me if their WARN Act applies to them. The WARN Act, which is a federal law that requires employers to notify and give employees a 60-day notice of intent to lay off when you're laying off more than 50 employees at a time or within a 30-day period. This law only applies to employers with 100 or more employees. The majority of employers that I typically speak to and have been speaking to are under that 100 employee head count. If you do have more than 100 employees and you're planning to lay off more than 50 people, please make sure you're speaking with your attorney about the appropriate actions that might need to be taken for that. Iowa unemployment applies, though, however, to employers that have shut down, are also laying employees off. And many questions that I'm getting is, how does this affect their unemployment claims and their tax rate as the employer? So the state has been very generous on their unemployment claims due to COVID-19 and has stated that those claims specifically paid out will not be charged to an employer's tax basis account when it comes to the calculation of your tax at the end of each year. The employers are still going to be notified of your claims, and there'll be no fact-finding interviews held. So it is really important that you make certain that you're notifying your employees how that they would apply for unemployment when laying off or shutting down due to the COVID-19 pandemic. So the state of Iowa has provided information that you can be giving to your employees, and you should put it in writing to those employees to make sure that they are aware of how to file for an unemployment claim if they have been laid off due to the COVID-19 pandemic. But one of the things that is good for employers to be aware of in this time that's very uncertain for everybody is that if an employees are laid off due to COVID-19 and they file for unemployment, your unemployment tax rate will not be affected. The state of Iowa also has made available a voluntary shared work program in an effort to try and keep employees employed. The voluntary shared work program is out here for partial layoffs or reductions in hours, and it allows employers an alternative to lay off. Basically what it does is it allows employers to reduce their work hours to employees between 20 and 50%. Iowa Workforce Development then pays a percentage of weekly unemployment based on the hours reduction for up to 1 year. There's a lot of requirements that you would need to comply with this law, including faxing in or providing a report to the state every week of hours worked for your employees. And your employer account is not charged for the benefits paid, but under this program, it could affect your tax rate at the end of each year. I know that there's been questions placed with the state on the voluntary shared work program on whether or not that would be still applicable if people participated in the voluntary shared work program, and the reduction in hours were due to the COVID-19. At present, I do not have more information on whether or not that would apply to affect your tax rate in the voluntary shared work program. I'm sure that the business partnership will provide additional information if there's additional information that comes out in the future about that. For more information about how to apply for the voluntary shared work program, I've provided the website link for you, and I will end up providing this presentation to the business partnership to provide to all of you that are listening today. Employees can go out to the iowaworkforcedevelopment.gov website and click on File a Claim on the top menu bar to submit a claim for unemployment. It is recommended that employees are filing a claim through the Iowa Workforce Development website instead of calling the number, because many employees are saying and reporting back that the phone number has really, really long hold times and sometimes they don't get through. So it's recommended that they file a claim through iowaworkforcedevelopment.gov website and file it electronically. They still must qualify as long as they've had information and submitted on the employer's returns in the 6 of the last 18 months. In addition, if they've earned $2,500 or more in the same period. Small employers should actually be going through and reviewing their policies for potential conflicts between the FFCRA and their policies. If you have unlimited PTO policies, some of the recommendations from various people that I've spoken to is, do you really have unlimited paid time off policies? Nobody has even thought of or was considering something like this pandemic when they wrote flexible PTO policies like that. But if you really truly do have a flexible PTO policy that has unlimited paid time off, you may need to revise that if you cannot afford to pay unlimited paid time off to your employees, especially during these times. My recommendation is to review your policy rules and potential caps to see if PTO can still be used after the FFCRA. And prior to publishing any policy changes with your PTO, it's recommended that you speak with your attorney to make sure that any policy changes that you're making are being made intentionally and consciously and ethically. It's important that your attorneys review policies anyway before you implement them with your employees, because you want to make sure they're in compliance with the regulatory guidelines. One of the biggest questions that I have had actually lately has been relating to paid time off when it comes to unlimited paid time off policies how does it work with the FFCRA, since the FFCRA is in addition to your normal policies. So it'll be important for you to review your policies, at least at present, to make sure what is it that your company can afford, what do you need to be doing, and is it really truly unlimited if you have unlimited policies. You should make sure that you review and post your notices for the FFCRA notice, which the Department of Labor has promised will be posted and made available no later than March 25th. Also, that you're posting the Iowa unemployment notices and information that's posted out on iowaworkforcedevelopment.gov. I've provided that resource for you on this site or on this web page, so that way employers can have that unemployment information clearly posted. If you do need to actually lay off your employees because of the reduction in hours or business shutting down because the governor stated that you need to shut down your type of business in order to try and slow down the spread of this pandemic, then please make sure that you're notifying your employees in writing that it's due to the COVID-19 related issues, so that way their unemployment claims can also continue to process faster. In addition to that, review your short-term disability benefits plans if you have those in place, and make sure that employees that are on your health insurance plans know that testing for COVID-19 will be covered at no cost, even on high-deductible health plans. That has been ruled and put in place by the IRS and approved by the IRS, as well as the insurance carriers that I have seen in the area. Short-term disability plans will generally cover those that have become ill with the COVID-19 virus after any elimination or waiting periods, and appropriate claims have been filed. So please make sure you're taking a look at any short-term disability plans for those that do become ill and communicating that information to your employees that might be covered on those plans. I'm going to go through some questions that have also been put in on the site. One of them is, does this apply to part-time employees who are not working now? Most of my employees work less than 15 hours per week. The FFCRA does apply to part-time employees that are working as of April 2nd. If you have laid off any of your other employees, my recommendation is that you do go through and you do make sure that you have given them the information on how to apply for unemployment. Even retroactively, it's recommended that you at least give them information on how to apply for unemployment. The other question that I have is relating to how unemployment works and whether or not somebody may have qualified in the last 6 months or benefit period time for the evaluation to determine whether or not they'd be eligible for unemployment. It's not just how much they may have earned at your business. It would be based off of how much any employer that they have worked for prior also may have earned during that period of time. And so Iowa Workforce Development will typically look at the last 18 months to see how much wages have been reported through various levels of employment with the state for unemployment. Another question that was received is asking about the voluntary shared work program, on whether or not the hours are reduced to 50% for a full segment of their workforce. And the voluntary shared work program is typically defined as those that are having between 20 and 40 or 10% and 40% reduction in hours. The hardest part about that is it's really hard to know. The best response that I can give to you is to have you actually reach out to the state directly and see if they're willing to do that. My guess would be in this particular situation, if an employer is paying anything for employees to continue working to keep them working, the state's going to want to work with you to encourage that. I would like to know if there's any other questions that are out there that I may not have addressed, or other questions that you might like to ask at this time.
This is Kim Casco. I'm seeing a question on the chat. If required, does Iowa have a definition of essential businesses? I don't know the answer to that right now. If anyone else kind of knows, feel free to chime in on that chat. I don't think that's the case.
I do know that some of the essential businesses are going to be related to the healthcare industry, food production and or delivery type of industry, so grocery stores, food preparers, etc. I do know that as other essential businesses, some business services are, construction is considered essential, utilities are considered essential, but things that I know that the state of Iowa at present are not considering essential would be things that could also potentially spread the virus quicker, which would include things like spas, gyms, recreational facilities, in order to try and encourage people to be staying home instead of coming into work. That's just a high-level overview. I do not have the website up at present.
Brenda,
So one of the questions, I do see another one of the questions is asking about the family leave that businesses with less than 50 employees only have to pay for childcare reasons. The family leave, under the FFCRA, the family leave, the only qualifying or eligible reason under the FFCRA for employers with fewer than 500 employees must pay for 10 weeks at 2/3 salary for employees that cannot work even remotely because they need to take care of their children because the schools are closed. And that does include employers with fewer than 50 employees. So any other good questions?
Someone asked if they can watch a playback of this. We are recording it, and once the webinar wraps up here, we'll get that posted, and like Brenda said, she'll share the slides as well.
And somebody else did make a comment that essential business is defined by the Department of Homeland Security. I wish I can say that's true across everybody. I've had some states that have made some slight changes to what the Department of Homeland Security has defined. If you do have a situation where the state or city that you are working in or have employees working in does do a shutter at home or a stay-at-home order, it will be important to make sure that you're finding out what that particular city or state is defined as essential businesses. Oh, somebody gave me an excellent and a really hard question. How are tips calculated for disbursement to employees? So the law itself, the FFCRA, is not basing information on how tips are included in employee wages at this point. At the very least, you do need to pay minimum wage to your employees during this period based on hours worked, not net income. Any other questions that we have today?
Brenda, this is Kim here, and I know this session is focused on FFCRA and Iowa unemployment. Are there other kind of tips you would have for our small businesses at this time in terms of navigating HR-related issues in response to COVID-19?
I would say that, reaching out to your HR professional that you work with, if you don't have one, of course, my company is also one that works with small businesses to make sure that you're complying with the notification requirements. You want to make sure, again, you're giving your employees notification in writing If it's a temporary layoff, you want to make sure that their notification says it's temporary and that they will be called back, and a time frame of when that will be reviewed, as well as information about how to file for unemployment. It might also even be better to go through and define if you're paying out any PTO to employees that are being laid off, because that'll just answer the question right off the bat when Iowa Unemployment asks for that question. Other things and suggestions that I would be recommending for small businesses is make sure you are reviewing your PTO policies before April 2nd. If you do have unlimited PTO policy, my guess is you need to make a change to your policy before April 2nd, because I'm going to bet that you can't afford to pay unlimited PTO in these particular times if you have to have periods of time where you have no revenue coming in. The other things too is I know a lot of people are asking a lot of questions, and I'm getting a ton of questions about, well, I have no revenue coming in, I want to keep paying my employees, I can't afford to, what other the financing options are available. I'm seeing there's another workshop that Kim, I think, is putting on this week or later today. I've lost track of the days, but that will be talking about SBDC financing. There's also a Iowa grant that has been announced last night for small businesses specifically to potentially help with lost revenues through the Iowa Economic Alliance. And then there's also, there's information that hopefully the government is going to have something available as well. Remember that the FFCRA payments that are made to employees are dollar for dollar refundable through your 941 tax returns. I have a question here about whether or not employees are going to be required to reimburse the Iowa workforce when the Fed stimulus is passed. Unknown. And so it's really, I highly doubt that, but it's hard to tell what the government's going to pass. I have another question on, we have an employee that received a doctor's note that says he's a higher risk and want him to be placed on leave. And that there's no work from home. In this particular case, you have a doctor's note that says that he should not be working, and so he potentially would qualify under the sick leave law and or under, if you're larger than 50 employees, family medical leave or unpaid. So under the Iowa workforce, another question that came in is asking about the order in which things are paid. The FFCRA is in addition to your company's own PTO policies, and the question is asking about the order in which that is paid. I had put on their company paid time off and FFCRA and then unemployment, and so really the order is irrelevant as long as those things are happening prior to employees being paid for unemployment, because the FFCRA itself is in addition to your own company's policies. Any other questions? You guys are asking great questions.
We had something come through on the chat in regards to treatment of exempt and non-exempt.
Let me go to the chat and take a look at that, sorry. So comments on treatment for exempt and non-exempt. So when you have employees that are off, hourly employees are very straightforward. So non-exempt employees generally are paid on an hourly basis. If you have hourly employees that are not working, you do not have to pay them. And they can go file for unemployment, etc. is the recommendation. If you have exempt level employees, remember that under the exempt level employees, if you have an exempt level employee that is off work due to illness, if they've exhausted available paid time off, then they can become unpaid. Generally speaking, exempt employees, you pay them their minimum salary each week, which is what is guaranteed and what you've agreed to. Under the Department of Labor regulations, you do have rules that you need to comply with when you're dealing with exempt level employees. And if they work on even 10 minutes on a day, you have to pay them for that whole entire day. It is always encouraged that if employees are able to work remotely, they want you to have them working remotely to help, of course, your business and prevent people from having to file unemployment to such a degree. But if you have employees, and especially with exempt level employees, it's important to make sure that you are paying them for their time. It has to be paid for the whole day, even if they only work for 10 minutes in that day. Non-exempt employees, if you have a non-exempt employee that is working remotely, it's important to make sure they're still tracking their time and that you are still paying them for their hours worked while working remotely. Any other questions? I see another question here. If I close my business, am I exempt from having to pay out the FFCRA? That is correct. If your business is closed before April 2nd, you do not have to pay employees the 2 weeks required pay if they become ill or have to stay home for childcare, or the 10 weeks of childcare if your business is already closed by April 2nd. Sorry, there's several other questions here. I don't want to miss any. If an employee has to start their leave before April 2nd, can they file for unemployment? And then when April 2nd hits, can they switch and go back on unemployment? So if an employee is on leave before April 2nd, technically, it depends on if they're considered on a paid leave, on an unpaid leave. You may want to talk to a legal counsel to try and get interpretation of whether, if they were already on leave before April 2nd, and whether or not you have to go back and include them in the FFCRA types of calculations. There's a lot of gray area in this particular law. When I was speaking with employment law attorneys at Shuttleworth Ingersoll just this week about this, their recommendation is if you have something that is more complex than just some of the basics of following the regulation, to make sure you're speaking with your legal counsel. Another question that came up is, what if your company cannot afford to pay for the 12 weeks of leave? You don't have to, an employer, if for those employees, in many situations such as this, are struggling to come up with that exact answer. There's funding available from the SBDC, funding available from banks, funding available from the Iowa Economic Alliance. In addition to that, I am seeing employers laying off employees and allowing them to file for unemployment. It's all about what's going to help you be able to reopen your business and be back up and running. All I can do is really tell you what the regulatory guidelines are stating. And remember that 12 weeks of leave is dollar for dollar reimbursable through your tax returns, and is covered under the FFCRA regulations. And if it turns out that that dollar for dollar amount that you have paid out to your employees is more than your income tax return filing would be on that quarterly return, the IRS will send refunds as quickly as possible to those employers. The next question is, once company PTO is exhausted, what does our employee have to do to obtain FFCRA paid time off? So ultimately, if an employee becomes ill or meets one of the 6 requirements under the FFCRA after April 2nd and they're still an employee, then you would want them to provide documentation that shows that they need to be there to care for their children, and or they have a doctor's note saying that they are ill or need to care for a spouse or a dependent. I would personally recommend that they at least get some documentation to have for your records that they would be eligible for FFCRA. If you're paying it out, most payroll systems are actually setting up special earnings codes to help employers track the FFCRA. If you're doing payroll in-house, my recommendation is also to set up a specific earnings code for the FFCRA, so that way you can track that and be able to quickly and easily document that when it comes to your returns when they're done at the end of each quarter. The next question is to confirm we need to exhaust PTO and sick leave before they can collect unemployment or we pay any wages out. So typically you would pay out paid time off when people leave employment. Not always, not all companies choose to do so. In this particular situation, Iowa Workforce Development is encouraging employers to pay out any available paid time off that employees might have. Employers are talking to their attorneys about whether or not that has to include sick leave, because if they're not sick, they didn't want to pay out sick leave. This is completely, the sick leave side of that is a decision that you make as an employer, and the PTO also bases on your own company's policies. Again, if you don't have any money to make any payments to employees because you have no income coming in, it leaves you one of two choices: to get loans and pay your employees, or to temporarily lay off. Kim, do you see other questions that may have come in that I may not have addressed?
No, I do not. Brenda, you did an awesome job covering all of those. And I'd like to just, wrap things up here by just thanking you, Brenda, for digging into all this, sharing your expertise with us, and thank everybody today, our participants, for joining us, for all your good questions. As I mentioned earlier, we have been recording this, and we will post the recording and the slides. We'll send it out via email. We'll get it on our Facebook page, our website, whatnot. Feel free to reach out to any one of us at the Business Partnership if you have any questions directly. Also, we've got a couple other webinars coming up this week. Tomorrow at 2 p.m., we have a webinar with our peer organizations, the Iowa City Area Development Group, Iowa City Downtown District, and Think Iowa City. And it is a State of the Community webinar. We'll have a panel of community leaders to share updates. Our 3 city administrators from Iowa City, Coralville, and North Liberty, as well as county leadership and University of Iowa. So please join us for that. 2 p.m. You can register. Again, the links are on our website and our Facebook page. And then also at 3:30, as Brenda mentioned, we've got a webinar with the Iowa SBA covering their disaster assistance loan. And we also sent out a communication earlier this morning about the governor's small business relief grant and tax assistance program. Applications, you can apply online for that. It started this morning, and those applications are due March 31st. So please take a look at that, and we'll be sharing out any additional information on that over the coming days. So thank you again for joining us today, and hope to see you all soon.